Welcome everybody. My name is John Byrd. I work out of the Pittston office, North Penn Legal Services. Um, as we're going forward, I'm going to have Adam introduce himself in a moment, but ask questions. I mean, otherwise you're just going to listen to me talk for an hour and a half and Adam talk for an hour and a half. And while he's probably much better at it, I think you'd much rather have a few folks jump in and ask questions and have some discussion. I think the overall theme was stuff we wanted to put on a PowerPoint slide, but I think it's a lot of really good individual, like interesting materials that don't come up all the time. So I'm actually excited about today. Adam, did you want to add anything or introduce yourself? I guess, right?
Oh, sure. My name's Adam Weaver. I'm an attorney in Carbon County. When I first started my career, I worked for Chapter 7 bankruptcy trustee in the Middle District of Pennsylvania. I did that for about 5-6 years, and then I opened my own law office. Part of my practice does involve defending against consumer debt collection efforts as well as bankruptcy. So more questions, the better, I think. I try to view these CLEs a little bit as also kind of like brainstorming sessions where we can bounce legal ideas off each other based on all of our collective experiences. So definitely, if you got any questions, make sure you send them, and I look forward to talking about this and some practical pointers based upon our joint experiences. Thank you.
So we have some procedural stuff to go through. We're going to kind of move quickly through the beginning slides, and then around slide 12, I think, is where the interesting stuff starts. But because this is for credit, right, I have to bore you for at least 10 to 15 minutes. Otherwise, the CLE board won't give you credit. We had this discussion. So process after filing a CCP, right? So you can file POs, answer a new matter, and then it will probably go to arbitration unless it's over $50,000, and then it goes to a hearing where we litigate. We also try at every stage to make sure settlement is an option. Let's see here. So POs, all POs must be raised at one time. If you file an amended, if the plaintiff files an amended complaint, your POs are moot. So one thing I want to say is don't be afraid to file many rounds of POs, right? So it's been my experience a lot of times where I'll have POs on like 3 different things, and then they'll correct one. So then I'll have POs on 2 different things, and then they'll correct one. And then I'll find another thing wrong. So I'll POs on 2 more things, and then, and we can just keep going that way. We're going to have a pros and cons coming up about POs in a little bit. So I don't want to go too far into that. So some of the most common, especially in consumer debt cases, is that they forgot to attach a writing, or they don't have the writing. So if it's based on a contract, the contract must be attached. Sometimes they'll have an improper verification. You may have, I don't know, Marge from Capital One, but we have no idea who Marge is, what Marge does, what Marge's title is. So that doesn't typically count. And then, demurrers, the fun stuff, which Adam has in a new issue on demurrer. Well, not new, but new to me. And I'm very interested in hearing more about that later. So keep your eyes open. So blah, 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 more things about preliminary objections. Let's get to the fun stuff. Whether or not folks are, they have standing, are they the actual party to bring the suit, all that fun stuff. So then it's my personal opinion that you should always be putting in new matter and counterclaims or whatever else you can put in. I think honestly not putting it is malpractice. But if you're, I don't see this from our attorneys. I don't. But when you'll see folks that are just denied, blah, 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 denied, like that's not an answer. That's something that was like photocopied out of the rule book. Like, let's make sure that we get in, some facts and some stuff like that. I think we all know the statute of limitations. Although one thing I want to say is look at the rules, right? Look at the documents that they provided. If they provide a contract and they're going to pretend that the contract is valid, it may have a shorter statute of limitations based on the governing law. So I think Delaware, and don't quote me on this one, but I think Delaware is 3 years. So if they're going to have a contract of a credit card based out of Delaware and they're suing after, after 3 years, well, great. We'll say, sure, the contract is binding. Absolutely. SOL, so sad, too bad. 1305, we have a 1305 memo that's been circulating for a while. Realistically, it gets in bills or documents. It tries to prove, maybe an amount. It does not prove that there was a contract, right? So really what we're trying to say is it stops the from having to have the plumber come in and testify that this is my bill and things like that. So or this is the normal course of materials that we produce. We've sent how many bills over the course or whatever that come in. It doesn't mean that necessarily the work was done, the work was done correctly, things like that. Okay, practical considerations. This is the fun stuff, right? So don't bring your client to a consumer debt case, especially a credit card case, unless notice to attend was provided. Or if you have some, I've had attorneys who have had valid, oh my God, what's that word, when they steal your money? Identity theft cases, right? Where they actually were going to put on an actual defense to identity theft. Well, they really can't do that without your client. But otherwise, don't bring them. They don't, the only thing they're going to do is validate the debt and have judgment against them. When you win, you want judgment entered in your client's favor, not dismissed, because they can appeal within 30 days. But if they don't appeal within 30 days, it's a judgment forever. Well, as far as forever is in the legal world. And then otherwise, they could just file again anytime before the statute of limitations runs out. So here's what we're talking about: pros of POs and the cons of POs, right? I think the cons are pretty strong, pretty in your face on that one. So yeah, it could buy you time. Honestly, it's often easier than drafting an answer because you have POs, right? So you really just have to change a brief and change a couple sentences on a pleading, and then you can file that to buy yourself some time instead of waiting to see. But every time, that allows the opposing counsel an opportunity to correct, and then you're stuck with whatever they have corrected, right? Well, give and take your denials and things like that, but sometimes it may be better to hold them to the fact that they don't have any documents, that they don't have whatever else. And it just depends. And everything's a procedure. Everything is I don't want to say a game, but there's strategic advantages to some things, and sometimes it just really comes down to what you have time to do. And it's easier to file a PO than to have a default judgment opened. And I think it looks better to file a PO than to have a default judgment open, especially when you've had a client for a couple of weeks. POs and cons of POs. I have a case right now where it's a mortgage foreclosure case, and they are missing significant portions of servicing records. And so we're in diversion. It's not quite POs, but I'm pushing them to get it, and they're telling me that they can't find it. And it might be better at this point to get out of diversion or, like a PO type of deal, and just start litigating the case, because if you can't produce it now, chances are you won't be able to produce it in a few months. But you never know. This is some of the stuff that Adam had thrown in about affirmative defenses that he uses often. Lack of privity, statute of limitations, which is some of the stuff we talked about, doctrine of latches. I always think Loch Ness Monster for some reason, but waiver. Then you have acquiescence and recoup and set off. Adam, did you want to talk about any of these in particular, or?
Oh, sure. I mean, I'll start a little bit more where you began a little bit here. When I first started representing debtors in these cases back when I think the seminal case is Commonwealth Finance System versus Larry Smith, which is a 2011 um, Superior Court case, which basically stood for the proposition that the credit debt collector needed to prove an agreement, provide a full accounting of how they accounted for the debt, and provide um, a valid assignment of a debt. So when I first started doing that, I used to file preliminary objections to a lot of these type of complaints, especially when they didn't have any documentation attached to the complaint that there was a full accounting. They just attached one or two or a couple credit card statements. Over time, I found just from a practical perspective, when you're looking at, cost of litigation and what makes more sense to do it, I found that I was probably billing clients more than what I could as a private practitioner than what they were willing to do. So I kind of, after that case came out, after I started filing preliminary objections, I know a lot of attorneys still file a ton of preliminary objections to these debt collection lawsuits, but I always found the more practical approach is when I'm at the Court of Common Pleas level, I want to be that attorney that just kind of ducks his head in the sand, gets it to arbitration and gets it undone, like under the radar. Because as most of us know, they're sending local counsel to these court hearings and whether at the magistrate level or at the arbitration level, including any bench trial appeals of the arbitration award. They're often sending local counsel with limited knowledge of the case, oftentimes without the full accounting or documents in order to prove their case. So I find that filing the answer, filing your affirmative defenses, and just like in Carbon County, we're a little slower than other counties. Like I know Lehigh County, for example, you file that appeal, you're getting an arbitration scheduled in 2 months. But in Carbon County, we're looking at 9, 10 months from the date you file your answer in new matter to when they reply to these eventually get into an arbitration hearing. So I find just trying to go under the radar, filing your answer, getting it to arbitration has often been the best litigation tactic from what I've been finding. Number one, one thing I did try when I first started, I actually filed a counterclaim to a credit card lawsuit under the Pennsylvania Fair Credit Extension Uniformity Act and the Fair Debt Collections because it was a debt collector. And I found that gets you on the radar very quickly where they start sending you discovery requests. They start filing pre-trial motions, whether judgment on the pleadings, where they say that you didn't intelligently respond to their allegation that the consumer utilized this credit card. They're saying that upon reasonable belief, your denial is really an admission. And it just, once you get on the radar, I think that's when it starts increasing litigation costs, especially for the client. And especially if you're looking at doing this on the limited time to save expenses to your client, I really find that approach to be the more useful rather than giving them the opportunity to amend the pleadings. I'm fine with them just attaching one document statement because that's a number one way my client can deny they don't have knowledge of the accounting because they never attached it. They never attached a copy of the agreement. They never attached a copy of the application that they filled out, whether it's electronic or not. And then you can raise some federal Truth in Lending Act stuff that that an agreement was never formed absent providing an application for credit. So from my perspective, that's my general approach when I'm defending a credit card at a arbitration level trial court scenario.
How often do you use doctrinal latches?
Oh, a lot of times I'll put that in there, because doctrine of latches, it is more of an equitable defense, but it's not as you can allege something that's less than the statute of limitations with the doctrine of latches. So if they sat on their rights, for example, if I've had cases where I'm involving defending a medical debt collection action, and whether it's ambulance or some other medical provider, and I find that they intentionally wait, for the 2-year statute of limitations to pass for their negligence actions if there's a defense that you weren't happy with their treatment. I represent one guy who said he was bleeding out in the ambulance. Might have been some malpractice by the paramedics. So they waited, a week before the 4-year statute of limitations filed, so that, of course, the statute ran on the negligence claim. So I tried to bring in the doctrine of latches under those circumstances to help defend the collection lawsuit for that. So
It's awesome. Never thought of it that way. That's a really cool, cool way to use it. Usually I just throw it in there and be like, hey, too long. But there's a valid reason I never thought of before. So here was my little soapbox issue that I was talking about earlier, and Adam also has it. So when I see a lot of people writing like affirmative defenses and then just list plaintiff asserts or defendant asserts the claim of blah 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 as affirmative defense, or asserts a affirmative defense. And realistically, under Pennsylvania, that might not pass the sniff test, right? So we are a fact pleading state, and if you don't put facts in, then you really aren't pleading anything. So the judge, the court, and everybody else is tasked with being aware of the law. So you actually don't have to put the law in, but you actually have to put in the facts. And there was a great discussion, and it is a common pleas court case, Golden, and they run through a whole bunch of different cases that were related to this issue or tangentially related. And you have Rule 1029, and then there's some language, and you can put plaintiffs or defendants or however, whatever position you're in, but they're barred in whole or in part by, and then you would put in your affirmative defense in that, and then you would add facts that support why the affirmative defense is applicable. But I think without facts, I think you can be in trouble.
Well, I agree with you, John. I just want to add a point to that. When you're raising facts in a new matter, what you're also doing is you got to make sure you have that notice to plead. I just got into that with a judge lately on a unrelated matter, but when in doubt, put a notice to plead on anything you file. Okay, just for a general, even if you think the judge is going to enter a rule to show cause, directing them to respond, because sometimes they won't enter that order, and then you go to a hearing and nobody's opposing it, and the judge says, well, I can't take any judicial establishment of facts because you didn't have a notice to plead on there. So that's just one of my practice pointers. When in doubt, just throw a notice on plead on everything you file, just to avoid those types of issues. But putting the notice to plead on your affirmative defenses, if you have facts in there, and let's assume the plaintiff does not file a response. There is case law out there that says you can't file a precipice for default for their failure to reply to your new matter. But what you can do is you can file a motion for default judgment based upon that. And that's something a trial court would have to sign an order on, because the trial court would have to look at what you specifically alleged in your new matter. And if he deems that there's facts as opposed to legal conclusions that required a response, they could enter a default judgment for you if they fail to file those reply to new matter. In Carbon County, I don't think I would get very far in that, because if I file a motion for default judgment, I'd probably get a rule to show cause, 20 days to respond. They schedule hearings on everything in Carbon County as opposed to entering judgments on pleadings. I'd probably have a hearing scheduled in 45, 60 days. Most likely they would file or apply to new matter in that time period. But I know other court systems, like I noticed motions court in Northampton County, you just send a fax. I'm going to have a show up for a hearing in 7 days on my motion for default for failure to reply to new matter. And maybe you get a lot more quicker response. So it would make sense to do it in counties where you can actually go to court relatively quick to have a hearing on that, as opposed to waiting 60 days after you file a motion for default and waiting for them to do that. But again, if they don't answer the new matter at the arbitration, you can bring that up as well. But if you don't have facts and you're just pleading the bare bones legal conclusions in your new matter, they technically don't need responded to under the rules. So you got to make sure you at least allege some sort of facts to support your new matter for that reason in particular, just because, you know, you can default that or at least have a additional ammo if you're going into an arbitration and they never responded to the new matter as well.
Awesome. As we're going through these two, I just wanted to point out that pack the slides so that there's reference material for folks afterwards. But the whole idea, I think, was to discuss and hopefully answer some questions and go through things that way. So like I said, don't be afraid to ask questions, and we won't sit here and read the slides unless we need to at the end for timekeeping purposes. But I don't think we're going to get there. But I think we. And this was something you brought up, and I think it's really interesting. Do you want to explain more about speaking to mirror?
Sure. When I find if you engage in some contentious litigation, there's some kind of rogue debt collector law firms out there that I have plenty of stories about. But the first time I really saw this issue is when they try to raise additional documents that weren't part of the pleadings. And they'll try to file either a motion for judgment on the pleadings or some other demurrer motion. And they'll just attach stuff that just randomly appears out of nowhere, you know, that weren't part of the pleadings. But the proper objection to that is actually called a speaking demurrer. So when a plaintiff tries to introduce new evidence on that wasn't admitted as part of the pleadings, that's called a speaking demurrer. So that's just one of my few areas. I know not many people hear of speaking demurrers, but I know in Carbon County there was a former judge that was really big on the speaking demurrer issue. So if there's something that just miraculously shows up in the court docket attached to the motion, that would be the objection to that.
And I think that's really interesting, even on a judge that may not typically grant something like that. If you hook their interest and they're like, because they're hearing the same things all day long, and all of a sudden you're like, wait, Your Honor, here, I've got this thing. It's called speaking to mirror. They may actually wake up enough to be like, okay, counsel, thank you. We're good to go, you know, something like that. We went through the repossession because some of the things we were talking about were topics that come up procedurally, like good ideas, which, you know, we went through a little bit now, and then repossessions and medical debt. And we really kind of just went through the rules line by line, because that's really what you have to do when you are defending against a repossession. And we have some stuff about mortgage foreclosure, or sorry, not mortgage foreclosure, mobile home repossessions and things like that. And you know, so hopefully you'll enjoy some repos. So some of the definitions as we're going through that when we're making the slides, we kind of realized sounded different than what we would normally use. So the holder is the holder of the installment sales contract, who you would think of the servicer of the loan in the mortgage company or things like that. Legal process, there's going to be two ways because there's the self-help method and the legal process method. And legal process just means that there was a lawsuit initiated, that someone in some way filed, you know, some type of action, replevin, a lawsuit on a note, things like that. Other than legal process does not mean that it's an illegal process. It just means that you're not following, you're looking more towards actual repossession. You know, the truck that drives around and finds the car, hooks it up to, you know, the truck and then drives it away. That's what we're talking about. Does not allow for breach of the peace, things like that. So the buyer, we're typically talking about the purchaser of the vehicle, not the purchaser of an installment sales contract later down the line, like some type of equity option or things like that. We're typically talking about the person who, you know, the consumer, the person that we're representing. So when can a vehicle be repossessed? So really you're looking at defaults under the contract, but, or I'm sorry, on the non-payment, right? But it can also be defaults under the contract, which specify as grounds for retaking the motor vehicle. And something, as I was thinking, as I was going through this, perhaps maybe trying to transfer the deed to someone else, or the, I'm sorry, I'm going to say words like deed and title, because I typically do mortgage foreclosure work, and in my head, I relate that back. But maybe if you try to transfer the vehicle to someone else who, you know, would have an issue in their security interest, then at that point, that might be a breach of the contract that would involve repossession. An installment contract, just so we're all on the same page, is any contract for the retail sale of a motor vehicle, blah, 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 as long as you're paying the sale price in 2 or more scheduled payments after the contract is made. So we're not talking about a hefty down payment and a balloon payment, but as long as you're doing some type of installment, you know, I guess it kind of is in the name, right? So who can repossess? I think here's where we're going to look to more specifics as to who's doing the action. So you have the judicial process, the litigation process, the legal avenue, where someone files a complaint and they're going to probably get judgment and then send the sheriffs to the house or to the home, to the car, and they'll repossess that way, or without the legal process, right? So if the holder of the installment sales contract or their official full-time employee. Now, I've never had to litigate anything like this, so I don't know how far a part-time employee would hold up, but the statute specifically says full-time employee. They have to be licensed, and we'll talk a little bit more about licensing later on. And if someone's trying to repossess a vehicle that is not a licensed individual to do so, there are actually some severe repercussions for folks or the entity that directed that. And really, we're looking at the people who originally sold the motor vehicle to the buyer under the installment sales contract. So really, just kind of, you know, whoever's owed, who's owed the debt is the person that repossessed. You could do it with legal process or without.
John, I'm gonna just interrupt you for a moment to let folks know that we're gonna launch the first poll. And if you would take a moment to respond to that, attorneys who are looking for CLE credits, we need to be able to confirm your attendance. Thank you. That'll be up for about 2 minutes. You may resume. Thank you, John.
All right, no problem. So legal proceedings. So on default, they're able to initiate a lawsuit. The buyer receives notice, and we're going to go pretty heavy into the notices in a couple of slides just to make sure everybody's fully awake. But then you can be responsible as the buyer for costs of the suit and reasonable attorney fees. And I think that's always a great area to litigate, is were the attorney's fees reasonable? So the notice, this is really what the notice has to have. I don't want to bore you, but realistically, you want to know who the amount owed. Really, it's kind of almost like that, like Act 91, Act 6 notice, like here's your right to cure, here's what we're gonna do. So if we don't hear from you within 15 days of this notice, we're gonna sell your baby, right? And I mean your car, like not your like actual baby. But just going through that way, you know, and just the different things, notice requirements, and you can just sit there with the rule and just check it off with the information as you're looking to litigate some of this, because some of this comes into play later on, whether or not they're able to get a default or a deficiency judgment, whether they're able to sue. And I think realistically, that's where we're going to see this. More so will be our clients will come in and say, my car was repossessed, blah, blah, blah. Now I'm being sued $15,000 in a deficiency judgment. And so then you have to sit back and, you know, go through and check all the boxes and make sure what they did was kosher, so to speak. So what happens about the stuff you left in the vehicle, right? So they get to repossess the vehicle, but the stuff that you have in your car is still your stuff as long as you get it within 30 days. After 30 days, the holder of the installment sales contract can dispose of the property in any manner that they choose. So it looks like they just got a new jacket, right? You know, nice little jacket in the back seat. Maybe a couple dollars in the cup holder. I don't think you get to offset any of that though on the deficiency judgment. Costs are assessed to the buyer, of course, as always, right? The person who has no money is the one who will be responsible for all of the costs and fees. And those are just some of the costs and fees that are usually typically assessed. So you can reinstate the contract, right? So if the motor vehicle is subject to an installment sales contract has been repossessed, then the holder may reinstate the contract by paying all past due installments or by making a satisfactory arrangement with the holder regarding the late charges, the cost of the suit, and the cost of retaking, repairing, and storing under the section we talked about a little bit back that way. And then, surprisingly enough, I'm not sure that this happens too often, but the holder may enter into a contract with the buyer to refinance the obligation. So you can look at refinancing as an option. So maybe if it hasn't quite hit your credit report, you can get a loan to cover that and not pay someone else. So they don't specifically say that there's the right to redemption, but I read the statute to say that there is a right of redemption for all consumer transactions if repossession is effected other than by the legal process. So if they do their self-help non-breach of the peace repossession and it's not a commercial transaction, then I believe that there is a right of redemption just based on the way the statutes, because they carve out specifically the commercial portion. So, we'll see. And then the holder has to retain the repossessed vehicle for 15 days after mailing the notice to the buyer. So they take the car, then they have to give you at least 15 days to come up with some type of payment arrangement or pay off the balance or whatever is due moving forward before they can sell the vehicle. So if they hold it for less than 15 days, I think there you have a solid defense against the deficiency judgment. So here's really just if the default of repossession, and that'd be some pretty impressive repossessions if they're defaulting within less than 15 days of the default under the contract. You really just have to pay the unpaid time balance, the accrued late charges authorized by the law, and any other amount lawfully due under the contract. So whatever you've contracted yourself into. And then if default exceeds 15 days, which I think would be the typically what we're talking about, is the unpaid time balance, accrued late charges authorized by law, cost of retaking, repairing, and storing the vehicle, and any other amount lawfully due under the contract. Now, when I was reading on this, I think when they say unpaid time balance, they don't just mean the last 3 months that you didn't pay. I think you may at that point have to fully, because we're terminating the installment sales contract, right? So now amount needed to redeem and terminate the installment sales contract, you have to pay the full amount owed. It's not just the last 3 months. Now, again, you may work with the lender, the installment sales contract owner, and say, hey, if I give you the last 3 months or maybe the next month or so, will you release the vehicle to me if I pay all the fees and things like that? And I think typically they have an amount in mind that if you contact them, then they will release the vehicle back to you. So where do they have to bring the car back, right? I always thought this was interesting. So if the buyer redeems and terminates the contract, so the vehicle must be brought to either the county where the repossession occurred the county where the buyer resides or where the vehicle was purchased. So they can't just be like, okay, it's your car, we release it, even though we repossessed it in Luzerne County, drove it all the way to Pittsburgh. We can't just be like, okay, here, come to Pittsburgh and get it. They have to bring it back to like Luzerne County or Lehigh County if that's where you purchased the car, something like that. So I thought that was interesting. I didn't actually think about that until I read through the rules. I think I just automatically assumed they would deliver it back in front of my house where you took it from, or more likely behind my neighbor's house where you finally found it when it was being repossessed and then took it from. So just an idea. They should return the vehicle as soon as possible, but not later than 10 business days after receiving the funds. So after you pay off and terminate the installment sales contract, you have 10 days in order to, they have 10 days, 10 business days to return the vehicle. If they sell the vehicle after repossession, then the buyer forfeits all claims to the motor vehicle and collateral security if they do not redeem by the termination period or the reinstatement of the contract within those 15 days. Unless there has been a public or private sale of the repossessed motor vehicle, then the holder may not bring a deficiency action. So we're looking again to see where the note's appropriate, where the notice is appropriate, was the deficiency, was it sold? And then I think at some point we also want to look to see whether or not it was sold for a reasonable amount. So when are deficiency judgments allowed? So they take your vehicle, they sell it to recoup, and there's still a balance left over. So anything that's due on the contract and the accrued late charges and anything that were costs that were allowed under 6256, which was listed a little while back, they can actually sue to recover costs like that. Reasonable value of the motor vehicle at the time of resale shall be determined by an action brought by the holder or the buyer. But it looks from everything I read that the burden to bring the action to determine the reasonable value of the vehicle is on the buyer. So if you have, and I don't really know cars, right? So if you have the Batmobile and they sell it for $15 at a public sale, I think you have the burden to say, hey, it was worth a heck of a lot more than $15. You're just skirting the facts to try to stick it to me later. The resale price of the motor vehicle is prima facie, but not conclusive evidence of the reasonable value of the motor vehicle. And the determined reasonable value or the resale price of the vehicle, whichever is higher, shall be credited against the buyer's indebtedness. So at least something cuts in our client's favor, at least just a touch. Adam, do you do any repossession work?
I haven't seen many state law repossessions, and I think that what you're bringing up is really great outline for, like, this outlines what you need to be looking for in your new matter in a potential counterclaim to a plaintiff's complaint. But I think what this also underscores is it's so easy for a plaintiff to slap together a debt collection lawsuit, but the defense of it is really complicated in comparison to just the slapping the debt complaint saying, and he's basically asking, for the court to say, hey, this person owes money. They still adhere to the old, it's immoral to be a debtor type philosophy. I think sometimes you get some of that backlash when you're going to like motions court and having a trial judge rule on some of this stuff. I think sometimes too they're not looking at these as exciting issues. They're like, oh, another debt collection case, and you're kind of making sure you get your affirmative defenses raised. You got to try to pitch it in a way that the judge is going to be a little more excited to talk about this case. And I think when you bring up a lot of the stuff that you went over in the slide, they're like, oh, that's makes it more interesting. I always find that bringing up the 13th Amendment and that we're not keeping them in a debtor's prison tries to add a little flair. I think I've even brought up, Geoffrey Chaucer's immoral priest debt collectors one time, just trying to get them a little bit more excited about the issues, and I see that a lot, especially in the mortgage foreclosure defense. They're just like, they're rolling their eyes. And I think I remember a former judge who was just like, this is not an exciting issue. And I'm like, you got to get excited and pumped a little bit about it. And I think it's important too, again, to raise what you're bringing up in the new matter, and you got to have facts pled. If you don't plead facts in your new matter, well, number one, you can't default them if they don't file a reply to it. And two, depending on how cavalier they are in their collections, they could be filing preliminary objections to your new matter, saying you don't have no facts, and then you're creating all this extra work for yourself. Well, I think that's in terms of repossessions. I mean, I do more bankruptcy work. There's always that question of whether a debtor doesn't sign a reaffirmation agreement and they still current on the loan. Does a technical default result in a repo of the car? I mean, that's always the theoretical issue. I remember researching like one unpublished Court of Common Pleas case. I don't think I've ever seen a creditor default someone just for not signing a reaffirmation agreement in a Chapter 7 bankruptcy debtor. That would just be a replevin case anyways, in terms of, if the debt was discharged. But
That's interesting too. And like you said, I think you're in a friendlier court, in a bankruptcy courtroom, than you might in a common pleas courtroom. And I think they might be more interested in helping the debtor, because nobody pays their debts in bankruptcy court. So that's the whole point.
And I think, just thinking about some of these issues, let's assume you're getting ready to go to arbitration, and then I think this would be an incredibly difficult case for a debt collector to prove at the arbitration level, especially when you're raising some of these defenses under the repossession statutes. I'm assuming they're going to go in, they're probably going to try to give you their 1305 documents, they probably won't have the required verification to authenticate the documents under, I think it's Rule 902. They'll probably try to say these are all admissible as billing statements, and I mean, the argument would obviously be that these aren't billing statements. These are correspondences, documents of an auction that happened. How do they get that in under 1305, under relaxed evidentiary rules? But one other thing I want to bring up too is if a plaintiff appeals, say you're successful at the arbitration court, and then they appeal, which would be a bench trial. There's a couple things you want to pay attention to. Number one, I think it's 1311, might be 1311.1. If they try to do the relaxation of the evidentiary rules at arbitration, they need to, number one, they need to stipulate that their claim is worth less than $25,000. If they don't stipulate to that, they don't get the relaxed evidentiary rules that were found in arbitration at the bench trial. And two, they need to reissue those notice of intent 20 days before the bench trial as well, and saying what documents they specifically intend to introduce. So if they don't do that, that's a objection right there, and a judge should, sustain that objection if they haven't followed the rules for relaxed admission of evidence, like into arbitration. And one of the number one rule that I got drilled into me earlier in my career is, especially in the credit card lawsuit, when they come and they don't have the documents, they send their local counsel there, who they tend to throw under the bus, I think, at these bench trial hearings. And that's one of the benefits of the tactic of tuck your tail in the head and just miraculously show up at arbitration or trial, is you're under the radar. They're not putting extra work into their case. They're not issuing you discovery requests. They send their local counsel, then they fax their local counsel probably a day or two before the hearing, the documents they want them to try to introduce. But when you go to a bench trial and they fail at the close of the plaintiff's case of liability and they fail to establish it, you have to actually orally move for a compulsory non-suit. And that is Pennsylvania Rule of Civil Procedure 230.1. So that's the rule you would make an oral motion for compulsory non-suit. And I think sometimes that slips people's mind for a little bit. I know one thing we do in Carbon County at the arbitration level is if the plaintiff fails to show up for the arbitration, which sometimes happen, you can actually go and get a court order for judgment in your favor as well. And I know it's easy to do that in Carbon County. We tend to have judges available for that.
It's been my understanding in our practice as well too. And then I think that's the bite is that, you know, you can appeal de novo from an arbitration award, but you cannot appeal de novo from a judgment entered by a judge for failure to appear at the arbitration. And, so I agree. You know, I don't think it's Carbon County specific, but it's fun when you get to do that. I agree. Thank you. So more boring stuff about what needs to be in the notice. It's been on the screen. I'm sure you had a chance to look at it. Oops. Manufactured homes, a little different, right? Because they live in it. So manufactured homes are the in between. Are they? And we did this in a bankruptcy CLE setting. But what is? Are they real property? Are they personal property? And they fall into the magical "it depends" category. And it really just depends on how you're, well, at least at the bankruptcy level, what your intention was at the time, whether or not it's something you lived in full time, whether or not it was identified. There's a whole bunch of stuff, but here's what we're looking for here is prior to, similar to a mortgage, right? You have to provide notice before accelerating the loan, or bringing legal action to recover under the note, or taking possession. So that notice must be in writing, and they get 30 days instead of 15 days for a vehicle, sent by registered or certified mail to the address where the manufactured home is located. And it must state the particular obligation or security interest, the nature of the default claimed, the right of the buyer to cure the default, and what needs to be done and how it must be tendered. Very, very similar to Act 91. And then, except there's no relationship individual. And the method by which the owner's ownership or the possession of the manufactured home may be terminated. So notice is required unless under MACRA, the buyer has abandoned the home or they have voluntarily surrendered the home. So a little bit increased protections for folks who live in manufactured homes. So the buyer or even someone on their behalf may cure the default and prevent the sale and avoid acceleration after notice has been given, but before title to the manufactured home is transferred. Sorry, I guess that column was supposed to be a parentheses. I'll have to fix that later. But you cannot do that more than 3 times in a calendar year. So you can't just keep going to default and then curing. So you may do that by paying cash or certified funds. What would have been due without the default or acceleration? So whatever you owed to, basically cure, you must perform all obligations, and you will be responsible as the buyer for reasonable fees and reasonable late penalties, including costs for transporting the home to the site of the sale. Now, I don't think that happens all too often because usually the homes that are being repossessed on, at least in our legal aid world, are not typically eligible to be moved. They weren't sturdy enough. And I found out recently too that there's laws in place that if a home is over a certain age, it cannot be brought on the highways to move it, regardless of the condition. So after a certain point, it becomes, I think, significantly difficult, if not impossible, to move the home from one spot to another. And once they cure, it restores the buyer as though the default had not occurred. So that's really a good legal position for the buyer to be in. So then we were talking about how do we get back at some of these banks, or folks who are, when we're looking at that new matter, we're pleading with particularity. our new matter. Folks repossessing vehicles outside the judicial process must have a license from the Department of Banking and Securities. So a while back, we said that they had to be licensed. Well, that's who issues the license. And failure to have a license may result in one or both of a fine not less than $2,000 or more than $10,000 and up to 3 years in prison. So that's a pretty substantial penalty, regardless. What is it? When you're trying to repossess, it's not really worth it, in my opinion. Hey. So if they violate a violation of this, violate a provision, or direct someone to violate a provision of the whole chapter that we're in, then they will have to pay a fine of not more than $2,000 on the first offense, or if it's after the first offense, they would have to pay the same fine and or imprisonment of not more than 1 year. So, still some pretty strong protections for the buyer, so folks aren't losing property left and right. It still doesn't stop the eviction. I think most people at this, or the repossession, I think most repossessors are familiar with the law and are licensed. I don't think I think it's something to be aware of. Not saying that's really going to be the Hail Mary. Maybe it will be in one case or another. If folks are unlicensed, right, then there's some significant fines, not more than $2,000, or imprisonment less than 1 year, or a fine of $2,000 for future attempts at repossessing by an unlicensed collector. And then if a person required to be a licensed individual under this chapter, chapter 62, right, directs a violation of this chapter or engages in an activity for which a license could be suspended or revoked under 6218, then they shall also be subject to civil penalty levied by the department of not more than $2,000 for each offense. So even just saying, hey, yeah, Steve, go collect this car, they're also, everybody gets sanctioned. And it's like Oprah, you get a sanction and you get a sanction. And the Department of Banking is just like, bring it in, fellas, bring it in. Please someone ask a question, so I stop talking.
Hey,
Other
John,
statute, yes.
I'll bring up some stuff here, because you're talking about criminal statutes and my thoughts on how you would raise that in a civil action. Okay, how I would probably couch it is I'd probably put that in my new matter when I'm answering the complaint. I would probably cite the statutes, and I would probably raise that as a recoup and set off affirmative defense. I know there's also the doctrine of unclean hands. I'm assuming that, well, maybe the plaintiff's attorney would argue that there's case law that says that the doctrine of unclean hands only applies to equitable actions and not monetary damage claims. But I think that's how you would probably raise that, is through a recoup and set off in a new matter claim. I know there's some cases out there, debt collection cases, where that kind of discuss in the federal court systems about the credit card not complying with the Federal Truth in Lending Act, and how that's a recoup and set off on the monetary dollar amounts that they claim. So I think if you're raising criminal statutes, I'd probably raise it or couch it in that mannerism. I don't know how you typically, if you do it any differently than that. Yeah.
That's interesting. Appreciate that. Yeah.
And just for anyone who wants to know the statute, I'm trying to remember off the top of my head, but I'm pretty sure it's 13 Pennsylvania statute 3305, which is recoupment and set off for notes, which are security instruments under the UCC. I know I bring that up a lot in the mortgage foreclosure defense when I'm trying to raise some sort of recoupment affirmative defense claim. But I think that would apply also because it's a commercial note for consumer debt. So I would think the UCC would apply as well. But
so, see, I'm going to write that down. I don't think I ever used that in my foreclosure pleading, so that's good to add another quiver an arrow to the quiver. And a lot of these statutes came from you, and I was back in mortgage foreclosure world when we started reviewing the usury statutes. So don't forget, you can claim against the folks who are repossessing. Unfair trade practice is a consumer protection law, 73 PS 201, 1 to 9.2. The federal truth in lending, which I haven't done much. Have you done a lot of truth in lending?
That's always part of my closing arguments to the judge every time I have a debt collection. I always like to bring that up. And, you know, I kind of view it as, like I kind of coach my son's soccer league, who's 7 years old. He's not the best runner yet, and but I always tell him sometimes you just want to get in there, even if you're standing in somebody's way, you're kind of being a little agent of chaos. Just get in there and throw yourself in there a little bit and see what happens. And I think sometimes you gotta confound people a little bit and going, whoa, what's this Federal Truth in Lending Act? And then you start bringing up the statutes, and I always give them the pitch that, these credit cards, they're heavily federally regulated industry, and that's how they're trying to get around the state usury laws, is because they're saying that they're federally preempted by the state usury laws when they're charging 29.99% interest, 32.99% interest. So I always bring up the Federal Truth in Lending Act, and I think in terms of the agreement element for the proof, I think you need an application signed by the debtor in order to establish an agreement under the Larry Smith case I talked about. I know there's annual disclosure requirements in the truth in lending law where every year they have to mail you a credit card agreement. I think it's a good argument to bring up, but I think when you bring up what year was the agreement entered, when it was when they originally took out the card, I think you're missing the application has a credit card agreement that attached to that. And there are certain evidentiary objections you can raise if they're not properly authenticating that. Most applications are submitted electronically, so there are certain evidentiary requirements in order for them to prove that. But I always talk about the usury laws, the Federal Truth in Lending Act, whenever I defend a credit card lawsuit. And I think that's another thing you can kind of put in your arsenal a little bit when it's the original creditor, because they're a little more challenging to defend against than a debt collector who can never have a bill of sale properly authenticated. And again, when you see the bills of sales, I can't tell you how many times I see the attorney trying to admit that under the relaxed evidentiary rules for arbitration as a billing statement. Is a bill of sale a billing statement? I say no, it's a contract. And a lot of times when they sell those contracts on the secondary market and the debt collector buys it, they're buying these whole group loads of assignments, and how can they specifically detail or link the chain of assignment to this particular debtor? And a lot of times they will get sidetracked through differing case numbers. A debt collector might have a different file number than original creditor. I'll look at the credit card agreements, which creditor actually owned this debt. If you look at the credit card agreements, most of the card, the company that actually bills versus the underlying creditor aren't the same as the plaintiff. There's probably about 3 or 4 different companies in that agreement versus the plaintiff. That's something I would bring up at the arbitration is that a proper assignment? What subsidiary company actually owes this debt? Just because it's Discover Bank as plaintiff doesn't mean that's who the debtor took the contract out with. It might be another subsidiary. And then how would the plaintiff prove that they have standing to sue for the debt over this subsidiary that's a entirely different corporate entity? So that's one thing I try to angle when I'm defending against an original creditor, and you don't need to cave, go, oh, he has all the statements. Well, make sure you look at which actually company is that, who's issuing the statements, who's issuing the credit, who makes the loans, who services it, because you're probably looking at 3 to 4 different companies, as opposed to just Discover Bank, And then did they even name themselves as a proper entity? Is Discover Bank NA? Did they even have anything to do with those transactions? If you read through some of those statements and the card agreements, the application, you know, so, but all that stuff is, I don't ask for discovery. I could ask for discovery, and you have the right to ask for discovery to obtain those documents. Like I said, I just like to do let's peel the Band-Aid off. Let's do this as quickly and as efficiently for my client as I can without racking up huge legal bills. Let's just get the arbitration done, get that final judgment. Maybe they don't appeal it, and then you press a P for judgment in your client's favor, and you got them out of the debt, or potentially avoid filing bankruptcy for a client as well.
There is something you said that I will take away from this training, and I hope if anybody else only takes away this from this training, is be an agent of chaos. And I think that alone right there is grounds for us all to get 1.5 CLE credits. I love it. And a lot of these other statutes were ones that you pointed out, the usury laws. Pennsylvania's usury law at 41 PS, and then the United States Code 15 USC 1643, where excessive interest need not be paid. One thing I want to point out to folks that are working on this in the mortgage foreclosure world, I always allege that something was above the Act 6, the usury laws amount, like if the interest rate was over, and the Department of Banking posts every month what the max amount is. And then I will say you were over this, and then we will try to recoup the amount of money that was paid over the interest rate and all the amortization that was over the allowed interest rate. But sometimes they'll have someone who is awake at the wheel, and they'll come back and say that the DIDMCA, the Depository Institutions Deregulation of Monetary Control Act, supersedes any state law, and it does not allow, it supersedes usury laws in the state. And the idea there was that they wanted to have the free flow of funding for homeowners. So in order to make sure that mortgage loans were more freely given, that you can't clap back with a usury law complaint. And that's really what that is, just to be aware of it. And I figured I'd throw it in there since it took me 15 minutes to remember the name of it and find it somewhere. So, and also absent a different interest rate in the contract, under Pennsylvania law, the interest rate shall be 6%. So I think a lot of us would love to have an interest rate of 6% on most things, except for mortgages. And then
just a note before you start talking about medical bill defenses, we're going to launch the second poll for everybody. So if you can respond to the poll in the time required, we'd really appreciate it. And here's the poll up, so you may resume, Adam or John, on medical bills. Thanks.
So what happens if I want CLE credit but I hit no?
Well, we could take care of the speakers. So if
oh no, I just meant like as an obstinate individual.
If somebody's having trouble with the poll, just direct message me and let me know you're having trouble taking the poll. But folks have been pretty good about participating, so we keep records so that when we're audited by the CLE board, we know that people are paying attention. So I appreciate your responding, guys.
Thanks. Medical bills. Adam, this was something I know was fairly something you were mitigating pretty well.
Yeah, I haven't really seen many medical bills like a regular hospital bill. I think that would be a very tough case for a plaintiff to prove, because every time you see your own medical bills when you go to a hospital, like I think I was just at urgent care and $100 copay. And then I look at the insurance statement and they billed on like $900 for me to go get antibiotics. And then the insurance company wrote it down to $150, So I don't know how they would prove the reasonableness of any billing. I think that would be a massive undertaking, which is probably why I don't see medical bills being sued for, I imagine, you would raise some defenses like unconscionability. It's just not appropriate billing. But of the medical things I have seen, it's mostly been from ambulance companies or like the medevac, the helicopter rides. But in terms of that, one of the things I found as a defense would actually be what's called balance billing. It's where they intentionally bill the wrong medical insurance company to deny the claim so that they can bill the patient for the full balance due. And part of the defense, it was an ambulance company. They charged, um, you know, about $1,500, to drive a patient about 5 miles up the road to drop her off at the hospital. No medical services really provided other than the transport. And they intentionally never billed she was a veteran, so there was, I think, Champfa was the medical insurance company, but they kept billing her over the course of, not often, but by the time a week before the statute of limitations ran, they filed their magistrate lawsuit, won at the magistrate, they appealed it. A lot of money, but what they had the patient sign was in the ambulance was a authorization to treat her medical bills. And they had a clause that if she doesn't pay the bill, and they didn't have a number of what the bill would be, that she would be obligated to reimburse them the reasonable attorney's fees and pay 18% interest on whatever was charged. So we raised medical duress. He's signing that under a medical emergency. In that case, she would have had like an allergic reaction. She couldn't even see. Her eyes were swollen, which is why they called the ambulance. But the basis of their claim, there was a $1,500 bill, and they sued her for $5,000, saying that 18% interest accumulated on that bill over the course of almost 4 years. So, and if you look at any of the insurance company, and there is some statutes that talk about veterans insurance coverage, is they only had like a 60-day window in order to bill the medical insurance company. And if they didn't, it was deemed waived. So I brought up the doctrine of waiver as an affirmative defense in that case as well. And I remember that case too, because I was one of those renegade debt collectors firms where I got an issue where there was a 90-day discovery deadline. On day 60, they faxed me 90 interrogatories and requests for production of documents, 30 requests for admissions. I had to spend like a weekend objecting because they didn't comply with the local rule that they need to ask me before they send 60 interrogatories to me. So I had 30 objections under the local rules for that. And then I issued my own interrogatories in response to ask what they did to actually bill the insurance company. And they filed an objection saying that they didn't have enough time because I issued it on day 70, that it's between 70 and 90 days. That was only 20 days. And therefore I didn't timely issue them under the discovery rule. And then we had to go to court. I filed a motion to compel discovery. The judge permitted them and they never responded to my request for admission. So I concluded they were deemed admitted. And then the judge gave them permission to amend their admissions and then compelled them to answer my discovery request. But that was just like, for a $5,000 bill, the amount of work that went into that case. And I think I did that under our local county modest means program. So we were only billing $75 an hour under that, but the amount of work was crazy that they would put into that. And then they went to arbitration arguing all sorts of weird quantum merit things and stuff that just didn't make sense to me in a medical service contract, but they probably spent it. And they would never disclose their fee agreement with their creditor either. So that they said they couldn't collect their legal fees at the arbitration was my argument. But we ended up winning it. But I knew I lost some of the arbitrators because I talked to them after the hearing. They're like, I don't understand this doctrine of waiver thing, So that made me realize I needed to talk more about that. What is an intentional relinquishment of a right? and how is that raised as an affirmative defense? So that taught me a little bit to explain more my affirmative defenses and what's it mean to actually file an affirmative defense. Sometimes I think we take that for granted a little bit. Not every attorney deals with stuff like that, especially in a consumer context, that you may want to take that additional couple minutes to say, this is the purpose of affirmative defenses, to offset against or defeat a plaintiff's claim based upon that. Just give a little more detail, explaining that a little bit more. But I was a little astonished that, none of the attorneys got the waiver argument. And I just kind of said, this is exactly what waiver is. They didn't issue the statement to the medical insurance. They waived their right to do it under insurance law. Now they're trying to do balance billing, which is prohibited under that statute. So
Adam, there's a question in the chat as to whether nursing home bills would be considered medical debts, or is that something to cover? We do see a fair amount of those claims come to NPLS.
yeah, I would be really curious to see one of those. I haven't taken a client. I know there's different statutes that we wouldn't really prepare the CLE. I think that's more of a specific area of the law, but I know there's at least some statute that talks about disposable income analysis. I recall reading that case where that was never raised, and I think they sued their children or something for a nursing home bill.
Because they have filial support laws where you're expected to take care of a family member who had taken care of you while you were growing a parent. And I think that's where whether or not you could afford to is when they look at your disposable income.
Yeah. Does anyone have questions? I'd love to have some questions or other ideas or some interesting scenario you want to brainstorm about. If not, we can just exchange war stories, I guess, John.
There you go.
Yeah.
So kind of go back to the other question. I know that they'll sue. So folks for nursing homes will admit someone under power of attorney or as next of kin, and then they'll try to sue the third party for services provided during the nursing care stay, because the individual has no income. So at that point, we have some pretty draconian laws in place that allow a nursing home to collect against a next of kin, pretty much. I know Diane in our office is one who has done a fair bit of legal work in that area.
Mm-hmm.
Yeah, I was just actually wondering if the defense of duress that you raised might work in the context of a nursing home. I haven't seen somebody try to use that as as a defense to a breach of contract claim, because a breach of contract is used a lot in these suits.
Right.
I don't know if you have any thoughts on that.
I mean, I think that would be a good defense to raise, at least on some of those. I would probably raise it, whether you can prove it at the end of the day might be a different story. Seems to be that's more statutory construction and what defenses you can raise under that. I haven't took a deep dive into that particular issue to know the true answer to that, but I definitely think you got to raise that as a affirmative defense. Like I said, more stuff you can raise in there, probably the better.
With facts.
Yeah.
Any other questions?
I just put a link. We have access. I just got that off Google from an NCLC article on defending nursing home debt. And I think that could be an interesting subject for another CLE. Individually, it's one of those things that we don't get that often, but is important to be aware of when it does come in. So I appreciate the work folks are doing on that issue as they come in. I want to know on notices, repossessions. We generally are not seeking affirmative claims, but we've been the recipient of some Cypre awards from class action lawsuits where notice for repossession was improper. across classes, deficient notice, both of the pre-repossession notice and the requiring the information to the person whose car was repossessed after it, with 2 requirements. And that's an issue that's been raised. And I'm wondering if there's on affirmative issues, is there at what point are you referring folks to seek sort of a consumer law specialist on an affirmative claim? Adam or John?
Oh, I don't know really if I really have an answer to that, other than if I see something that's like flagrantly, that might be like more prone to a class action lawsuit. I know there's consumer protection attorneys out there that specialize in that particular thing. I know I wouldn't try a class action myself as a solo attorney, but definitely if it's something that it looks like it's a flagrant violation and it seems like it's a normal business letter that they routinely send out, then I would probably sniff around and go, this might be class action worthy. Or maybe is this something I just want to try on an individual level and file a lawsuit, or wait to raise that as an affirmative defense and counterclaim if you ever get sued for a deficiency judgment.
And with your experience, do you do much litigation in bankruptcy court?
When I was a attorney for a Chapter 7 trustee, we did a lot of litigation in bankruptcy court. I don't see it as often now in representing consumers, which I mostly do now. I remember one time I think I had to litigate against a mortgage lender because they refused to accept the payoff and they mailed the check back to the seller. They wouldn't refuse to accept the payment. That was a weird case where I had to file a motion to compel them to accept the payment when the debtor sold her house. But sometimes you file objections to proof of claims based upon like the same affirmative defenses that we talked about today. There is bankruptcy claim litigation regarding these similar issues that has different sets of rules. For example, a creditor who files a proof of claim has a prima facie case that the debtor has to overcome first. And I know there's a debtor's attorney attempted to file an objection based upon that Larry Smith case, saying that they haven't presented a sufficient evidence to the proof of claim regarding the agreement, the accounting of the debt, and the assignment. And the bankruptcy judge didn't really want to hear any of that. And they're like, well, it's a prima facie case. You haven't met your burden of persuasion to say I need an evidentiary hearing on this, this type of issues.
So
Any other questions out there? Or cases, interesting cases, folks want to get some feedback on?
Yeah. Well, John, in general, I don't think I've ever had maybe one time. There was actually one time where I actually got a notice to attend issued by a plaintiff for my client to appear, and I remember that one time it did happen. They showed up and they just, got gruffy and they're like, I called the debtor to the stand. And I'm like, go ahead, and they tried to have her authenticate the documents and they're like, I never seen this one before, and it was like, I don't know who this is. My agreement was with Chase Card Services, not Citicorp. I had her nicely trained though, my creditor was this. I don't know who this new creditor is, because all the documents said that she signed up with, I think, Card Services and nothing to do with Chase Bank, who was the plaintiff. So that was my one experience with that happened.
I found that we typically don't get them unless it's a local bank, credit union that they take the debts personally sometimes. So I had one deficiency in a mortgage foreclosure case, and that was because the person who lived there, I don't know how true this was, but the bank had stated that they destroyed the place, that they were selling drugs out of the house, that there was a drive-by shooting, there was bullet holes all over the walls and things. So they wanted a deficiency. And we were able to settle that because I explained what a Chapter 7 bankruptcy would cost her and why should she pay more to them than what she would pay to get the whole debt discharged anyway. And they were okay because they just wanted their pound of flesh and they wanted her to pay something, and she didn't have to file bankruptcy, but that was the only time I've ever seen a deficiency in a foreclosure. We do get them like not a ton for car vehicles or car vehicles for vehicle repossessions and things like that, but that's why I thought it'd be interesting to go through some of this. One just came in not that long ago, and none of us had the rules ready at the top of our head. So I thought that might be a good thing to add as a place to look back on if you need them in the future.
And I agree. I rarely see deficiency claims, especially in a mortgage foreclosure, unless it's like a credit union. Like I know a credit union, that's one of the big ones that will actually go for a deficiency judgment. I think that might be because they use more local counsel too. Maybe they're looking for extra work. Hey, you gotta get that deficiency judgment in, keep the
Right, more billables.
Yeah, more billables, But and they're like, even though this person doesn't have money to pay that deficiency, they still go through the channels anyways.
Right. That's the thing too. If you could have afforded to pay, if you could afford to pay a deficiency, probably would have made your mortgage payments or your car note payments or whatever. Yeah.
I'd be curious if you ever defended a deficiency judgment action. If it's, I assume most made national mortgage companies don't do it because they have contracts and agreements that bail them out of the loan with their whatever trust that they have engineered with. So I'd be curious to see what trust agreements say if you probably ask for that in a discovery if you ever found yourself defending a deficiency judgment action.
Thank you, John Byrd and Adam Weaver, for offering your expertise and a lot of great information on pleadings and sort of special areas where consumers face challenges and need good lawyers on their side. So thank you.
Thanks, everybody. Thanks, Lori. Thanks, Adam.
Thank you.